Hello, everyone. Welcome to my channel, Us Fresh Update. My name is Lexalor. Breaking news. Millions of Americans believe U.S. citizenship is permanent, unbreakable, and guaranteed for life. Once you have that passport, the right to vote, and the protection of the Constitution, most people assume there is no going back. But that assumption is not entirely true. Under U.S. law, there are specific legal and carefully defined circumstances where American citizenship can be lost. Some are voluntary, others are enforced by the government, and a few are far more serious than most people realize. Today on USA State, we are breaking down the real facts, the real laws, and the real cases behind how U.S. citizenship can legally be taken away. Before we begin, make sure you subscribe, like, and share this video. It costs you nothing, but it helps this channel reach more people who want clear, factual, and professional explanations of the laws shaping the United States today. Citizenship in the United States is one of the most powerful legal statuses in the world. It grants the right to vote, the right to live and work permanently in the country, access to federal benefits, and protection under the Constitution. There are two primary ways someone becomes a U.S. citizen. The first is by birth. Anyone born on U.S. soil, including U.S. territories, or born abroad to at least one U.S. citizen parent under certain conditions, is considered a citizen at birth. The second path is naturalization, a legal process through which immigrants earn citizenship after meeting strict requirements set by federal law. Both groups enjoy the same constitutional rights. However, when it comes to losing citizenship, the law treats them differently. Citizenship by birth is extremely difficult for the government to challenge. Citizenship obtained through naturalization, while still strongly protected, can be reviewed and reversed if it was obtained unlawfully. This distinction is at the center of most citizenship loss cases. The simplest and most straightforward way to lose U.S. citizenship is voluntary renunciation. This is a formal legal process and cannot be done casually or accidentally. A person must appear in person at a U.S. embassy or consulate outside the United States and sign an official oath of renunciation. During this process, the individual confirms that they fully understand the consequences of giving up U.S. citizenship. There's also a significant government fee, which as of recent years exceeds $2,000. Once the renunciation is approved, the decision is permanent. The individual loses their U.S. passport, voting rights, and eligibility for federal benefits such as Social Security, unless specific exceptions apply under existing law. If they later wish to return to the United States, they must apply for a visa like any other foreign national. Each year, thousands of Americans living abroad choose to renounce their citizenship. Some do so for tax reasons, as the United States taxes based on citizenship rather than residency. Others renounce for personal, political, or long-term residency reasons after fully committing to life in another country. Regardless of the reason, once citizenship is formally renounced, it cannot be restored automatically. The more controversial and lesser-known pathway is government-led denaturalization. This process applies only to naturalized citizens. Denaturalization occurs when the U.S. government proves that citizenship was obtained unlawfully. The most common reason is fraud or material misrepresentation during the immigration or naturalization process. This can include failing to disclose criminal history, using false identities, hiding past immigration violations, concealing participation in human rights abuses, or providing false information about affiliations with certain organizations. Under U.S. law, there is no statute of limitations for denaturalization cases. That means citizenship can be challenged even decades after it was granted if new evidence comes to light. Denaturalization cases are handled through federal courts. The government carries a heavy burden of proof and must present clear, convincing, and substantial evidence. Individuals facing denaturalization have the right to legal representation and the right to contest the claims in court. These cases are not administrative shortcuts. They involve formal litigation and judicial oversight. There are real cases that demonstrate how this process works. Individuals who concealed involvement in war crimes abroad, including during conflicts in Europe and elsewhere, have had their U.S. citizenship revoked after investigations uncovered the truth. In other cases, individuals linked to historical atrocities were denaturalized and later removed from the United States once their past activities were proven. These cases span decades and show that denaturalization is not theoretical. It is rare, but it is real. Another legal risk involves post-naturalization conduct that contradicts the oath taken during the citizenship process. If within 5 years of naturalization, an individual joins or actively supports an organization that advocates the violent overthrow of the U.S. government, serves in a hostile foreign military, or takes certain positions within a foreign government without required authorization, the government may review whether the original oath was taken in good faith. In such cases, the argument is not simply about later behavior. It is about whether the individual misrepresented their intentions during naturalization. Each case is evaluated individually, and not all foreign affiliations trigger legal consequences. However, certain actions can raise serious legal questions. Dual citizenship is another area that often causes confusion. U.S. law generally allows dual citizenship. Many Americans legally hold citizenship in another country without any issue. Simply having a second passport does not mean U.S. citizenship is at risk. The key factor is intent. If a person obtains foreign citizenship with the clear intention of relinquishing U.S. citizenship, or swears an oath of exclusive allegiance that explicitly renounces loyalty to the United States, legal consequences may follow. Holding high-level government office in another country or engaging in actions that directly conflict with U.S. sovereignty can also trigger legal review. Again, these situations are evaluated case by case and are relatively uncommon. The most extreme and rare circumstances involve treason, armed rebellion, or acting as an agent of an enemy state. These cases are extraordinarily uncommon and involve serious criminal charges. Loss of citizenship in such cases occurs only after conviction in federal court and extensive legal review. These are not symbolic actions. They are full legal proceedings governed by constitutional safeguards. Many Americans are unaware that the Department of Justice maintains a dedicated unit responsible for denaturalization cases. This unit works in coordination with other federal agencies to review historical records, immigration files, and documentation. Modern investigative tools, including advanced databases, have made it easier to identify inconsistencies that may not have been detected years ago. When credible evidence is found, a case may be referred for prosecution in federal court. If citizenship is revoked through denaturalization, the individual loses all rights associated with citizenship. They no longer hold a U.S. passport, lose voting rights, and may become subject to removal proceedings depending on their immigration status. This is why denaturalization cases carry life-altering consequences. What about people born in the United States? For them, citizenship is overwhelmingly protected under the 14th Amendment. The government cannot strip citizenship simply based on conduct or beliefs. The rare exception involves fraudulent birth claims. This includes falsified hospital records, fabricated parentage documentation, or organized fraud schemes involving false claims of U.S. birth. These cases are extremely difficult to prove and are pursued only when substantial evidence exists. Across all these scenarios, a common theme emerges. Loss of U.S. citizenship is not arbitrary. It is rooted in intent, deception, and legality. The government cannot revoke citizenship without due process, evidence, and judicial oversight. The legal threshold is high, but when it is met, the consequences are permanent. The bottom line is this. U.S. citizenship is a powerful legal status that offers rights and protections unmatched in many parts of the world, but it is not immune to the law. Understanding how citizenship works, how it can be lost, and why the rules exist is essential for both citizens and immigrants alike. This is U.S. Fresh Update, committed to bringing you factual, professional, and in-depth coverage of the laws and policies shaping America today. If you found this video informative, make sure to subscribe, like, and share. Your support helps this channel continue delivering clear and responsible content. Leave a comment below with your thoughts or questions, and thank you for watching.